Um, this is Department Circular number 015, um, promulgated on July 16 of 2024. This has amended Rule 112 of the Rules of Court on preliminary investigations and inquest proceedings. So let's just talk about the important parts of this department circular. So first, no, the title is 2024 DOJ NPS Rules on Preliminary Investigations and Inquest Proceedings. Mm. The coverage is the conduct of a preliminary investigation proceeding shall be required for crimes or offenses where the penalty prescribed by law is at least 6 years and 1 day without regard to fine. Kasi sa Rule 112, 421, yun yung tinatandaan natin doon. 421 ngayon, 6 years and 1 day without regard to fine. So, it is implied, no, the all cases filed in the RTC, kasi sa RTC ay may jurisdiction to cases with imprisonment of 6 years and 1 day, of at least 6 years and 1 day. So, lahat ng ipa-file sa RTC with an imprisonment of at least 6 years and 1 day shall require a preliminary investigation. This notwithstanding, the investigating prosecutor may motu proprio at any stage of the proceeding dismiss the complaint if there is no prima facie evidence with reasonable certainty of conviction as defined in Section 1, Rule 2 hereof provided. Ayan. So, ano yung quantum of evidence now required? So, dati kasi is probable cause, no? Pero nakakalito kasi probable cause si investigating prosecutor and then probable cause ulit kay judge. So, ngayon, because of this DC-015, ang quantum of evidence na of the investigating prosecutor is this one, prima facie evidence with reasonable certainty of conviction. So, this quantum exists when a prima facie case is established by the evidence at hand, including but not limited to testimonial, documentary, and real evidence, and such evidence on its own and if left uncontroverted, on its own and if left uncontroverted, shall be sufficient to establish all the elements of the crime of the offense charged and consequently warrant the conviction beyond reasonable doubt. The quantum of evidence is met when the prosecutor is convinced that the entirety of the evidence presented by the parties is admissible, credible, and capable of being preserved and presented to establish all the elements of the crime or the offense, as well as the identity of the person or persons responsible therefor. Reasonable certainty of conviction also includes the summary evaluation of the evidence presented by the respondents through their counter affidavit. Okay, so Rule 4, Preliminary Investigation. So, preliminary investigation is a summary proceeding to determine whether a person should be indicted in court after ascertaining based on evidence provided and after case build-up has been conducted, in case where case build-up is necessary pursuant to Section 5 of this Department Circular, that there is a prima facie evidence with a reasonable certainty for the respondent's conviction and that he or she should be held for trial. Virtual preliminary investigation is allowed as an alternative means. It is a conduct of PI through video conferencing using appropriate information and communications technology. This may be availed at the initial hearing where both parties are present and the ICT therefore is available to both prosecution office and of the parties. So who are the parties? The complainant and the respondent. The complainant is the offended party. The respondent is the party being charged with the commission of the crime or offense or violation of an ordinance or against whom the complainant affidavit is filed. So sa submissions, we have complaint affidavit. This is a written statement charging a person with a crime or offense or violation of our ordinance subscribed by the offended party, a person authorized by Section 5, Rule 110 of the Rules of Criminal Procedure to file the complaint on behalf of the offended party, a law enforcement officer, or any public officer charged with the enforcement of law violated and sworn to before a prosecutor or any government official authorized to administer oath or in their absence or unavailability before a notary public. Next is a counter affidavit. This is a written statement by the respondent indicating his defenses. A reply affidavit is a written statement by the complainant which answers new allegations in the counter affidavit, and a rejoinder affidavit, written statement by the respondent in response to the reply affidavit. All affidavits as defined above shall include affidavits of witnesses and other documentary evidence attached thereto. Oops. Okay. A motion for suspension of the proceedings by reason of prejudicial question may be allowed. So, prejudicial question may be allowed in all conditions, therefore, under existing rules are present. But there is no bill of particulars shall be filed in lieu of a counter affidavit. Under Rule 5 is the inquest proceeding. So, an inquest is an informal and summary investigation conducted by a prosecutor or other officers allowed by law in cases involving persons arrested and detained without the benefit of a warrant of arrest issued by the court for the purpose of determining whether the said person should remain under custody and correspondingly be charged in court. E-inquest, as an alternative, is the conduct of inquest through video conferencing using the appropriate ICT. Okay, so the period to resolve the cases. All preliminary investigation complaints shall be resolved by the investigating prosecutor within a period of 60 calendar days from the date of assignment, with a maximum of 30 days extension in capital offenses, complex issues, counter charges, consolidation of related complaints, reassignment. The recommendatory resolution and information shall be transmitted to the head of office for approval within 5 calendar days from the date of resolution. The recommendatory resolution or information shall be acted upon by the Prosecutor General, City Provincial Prosecutor, or his authorized deputies within 10 days from the receipt of the resolution and information, and the resolution shall be promulgated within 5 days from its approval. While on inquest referrals, it shall be resolved within the day and transmitted to the head of office for approval on the next working day. So, bakit mas mabilis sa inquest? Kasi nga, he is arrested. Now, he is detained without the benefit of a warrant of arrest. So, let's move on to the remedies. So, the remedies available is a motion for reconsideration, that the aggrieved party may file a motion for reconsideration of the resolution within 15 days from the receipt of such resolution. The MR shall be assigned to the investigating prosecutor or another prosecutor within 3 days from the filing thereof, and it shall be resolved within 30 days from the date of assignment. Petition for review. Resolutions of the Prosecutor General or the City Provincial Regional Prosecutor on PI or motion for reconsideration may be subject for a petition for review or appeal pursuant to DC number 27, provided that the petition for review shall be accompanied by a motion to suspend proceedings as filed with the court. However, resolutions of the Prosecutor General and the Regional Prosecutor on appeal of the cases cognizable by first-level court shall be final and no longer be appealable to the Office of the Secretary of Justice. The resolution of the Secretary of Justice on appeal in criminal cases cognizable by second-level courts shall be final, executory, and non-appealable. Next, a petition for reconsideration on petition for review. The aggrieved party may file a verified motion for reconsideration of the resolution within 15 days from its receipt. And yan, this is the end of the DC 015, which repealed Rule 112 of the Rules of Court.